Mr. Pickering.
My Lords, before the break, I'd taken you through my brief chronology and the 4 stages. And I concluded with stage 4, which involved the actual dissipation of the proceeds of sale of the trust property. And I'd taken your Lordships to various passages in the underlying judgment, which set out the ways in which Mr. Stevens assisted at that stage 2, 3 years after the original self-dealing transaction with which he also assisted. My Lord Mail's asked the relevance of that. In one sense, it's of little relevance because the court has found that there was assistance and there is no appeal against that particular decision. I refer to it now merely for context, and it'll become of greater relevance when we deal with my friend's position in relation to separate and discrete causes of action. So it's merely for context. It's not the case that a self-dealing transaction took place and then profits were immediately afterwards enjoyed. There are considerable stages, not just in terms of time, but actual things which happen are set out in more detail in the judgment.
Just before you go on, can I follow on from a point my Lord raised before lunch, for whatever significance it may have? If I understood you correctly, you were suggesting that the hotels came to be held on trust for your client.
My Lord, at stage 2, when transferred from HMS to Cambodia Madeira, they were held on a Type 1 constructive trust. Yes.
And that I query, because as you say, the hotels were transferred in breach of the self-dealing rule. The self-dealing rule gives you a right to rescind. But unless you rescind, the property remains where it is. That's not to say you can't get an account of profits, but you can't both keep the proceeds of sale and claim to own the property sold.
My Lord, I'll be taking your Lordships in due course to the case of J.J. Harrison and Harrison, which describes that position. Well, in fact, it might be an appropriate moment now, but in short, and this is a case which was referred to at length at the trial, to which the judge referred. In short, where, particularly in the case of a Type 1 situation, a director self-deals, even after a sale for consideration, which is the J.J. Harrison case too, the recipient, the director, holds on constructive trust, a Type 1 trust. Lord, it might, given your Lordship's question, this is actually key. I think my little friend has had accepted that was the position, but it's probably...
I think he may have done. I'm querying whether, if he did, he was right. I'm not sure that would be consistent even with House of Lords authority.
Lord, perhaps in that case, I can take your Lordships to some authorities now. I was going to deal with, it's probably simplest if I deal with these authorities before I go to my overarching submission.
I don't know, actually, Mr. Pickering. You shouldn't allow yourself to be diverted. I'd stick to the course you had in mind, and we'll come back to these points.
My Lord, yes. My Lord, I will actually, with respect, take your Lordships to the authorities now, if I may.
Yes.
As I say, my Lord had accepted the point yesterday. If your Lordships require some persuasion on that, it's probably sensible that I deal with that up front. My Lord, in terms of the key authorities, I'm grateful to my friend for taking your Lordship through many. There are only 4 or 3, I think I need to take you at this stage. They're all well established. Your Lordships will be familiar with them, no doubt, but they're useful. The first is the Paragon Finance. Lord Justice Millett, as he then was. Your Lordships will find that at tab 9, which you'll find in tab volume 2.
I think it's volume 1. Volume 1.
So, apologies, in volume 1.
Tab 19.
Apologies, it's tab 19.
Which is volume 2.
Apologies, my lords, we're using different bundles from my friend in the your lordships will probably be familiar with the facts, but in short, it was a claim by a mortgagee against defendant solicitors. The case primarily is concerned with limitation, but it contains the classic description of the two types of constructive trustee. And in fact, this description permeates the subsequent case law and remains good law to this day. My lord, the relevant passage your lordships will find at page 746 of the bundle, and it's page 408F of the report. I tell you, Lord Justice Millett said, before 1890, when the Trustee Act came into operation, a claim against an express trustee was never barred by lapse of time. The Court of Chancery had developed a rule that, in the absence of laches or acquiescence, such a trustee was accountable without limit of time. The rule was confirmed by Section 25 of the Supreme Court Judicature Act of 1873, etc. The explanation for the rule was that the possession of an express trustee is never in virtue of any right of his own, but is taken from the first for and on behalf of the beneficiaries. His possession was consequently treated as the possession of the beneficiaries, with the result that time did not run in his favour against them. The rule did not depend upon the nature of the trustee's appointment, and it was applied to trustees de tort and to directors and other fiduciaries who, though not strictly trustees, were in an analogous position and who abused the trust and confidence reposed in them to obtain their principal's property for themselves. Such persons are properly described as constructive trustees. Regrettably, however, the expressions constructive trust and constructive trustee have been used by equity lawyers to describe two entirely different situations. The first covers those cases already mentioned, where the defendant, though not expressly appointed as trustee, has assumed the duties of a trustee by a lawful transaction, which is independent of and preceded the breach of trust, and is not impeached by the plaintiff. The second covers those cases where the trust obligation arises as a direct consequence of the lawful transaction, which is impeached by the plaintiff. A constructive trust arises by operation of law whenever the circumstances are such that it would be unconscionable for the owner of the property, usually but not necessarily the legal estate, to assert his own beneficial interest in the property and deny the beneficial interest of another. In the first class of case, however, the constructive trustee really is a trustee. He does not receive the trust property in his own right, but by a transaction by which both parties intend to create a trust from the outset and which is not impugned by the plaintiff. His possession of the property is coloured from the first by the trust and confidence by means of which he obtained it, and his subsequent appropriation of the property to his own use is a breach of that trust. Well-known examples of the constructive trust are a case for secret trust, where the defendant agreed to buy property for the plaintiff, but the trust was perfectly recorded. Appellant and Morgan, where the defendant sought to keep for himself property which the plaintiff trusted him to buy for both parties, is another. In these cases, the plaintiff does not impugn the transaction by which the defendant obtained control of the property. He alleges that the circumstance in which the defendant obtained control make it unconscionable for him to thereafter assert a beneficial interest in the property. The second class of case is different. It arises when the defendant is implicated in a fraud. Equity has always given relief against fraud by making any person sufficiently implicated in a fraud accountable in equity. In such a case, he is traditionally, though I think unfortunately, described as a constructive trustee, and is said to be liable to account as constructive trustee. Such a person is not in fact a trustee at all, even though he may be liable to account as if he were. He never assumes the position of a trustee, and if he receives a trust property at all, it is adversely to the plaintiff by an unlawful transaction which is impugned by the plaintiff. In such a case, the expressions constructive trust and constructive trustee are misleading, for there is no trust and usually no possibility of a proprietary remedy. They are nothing more than a formula for equitable relief. My Lord, so in short, two types of constructive trustee. Type 1, the fiduciary obtains control of the property by lawful transaction. as in an express trust. A director is properly appointed as will be in control of the company's property. It's a trust-like responsibility. For example, second class of case is prior to the transaction in question, the person in question isn't a constructive trust. It has no trust-like responsibility towards the property, but gets control by the transaction in question. So in the former, the person in question has responsibility of the trust property before any wrongdoing. In the second, it's by the wrongdoing. My Lord, that was expanded upon or considered in the case of J.J. Harrison. My Lord, that was the case, which, as I mentioned, was considered in some detail by Mr. Justice Foxton at the trial. It's at tab 28, and that will be in volume 4, my Lords. It's worth recounting the background because it is similar to the facts of the present case. In short, the company was owned by a brother and 3 sisters. It owned land which had development potential. The brother sought to buy the land. So, and I should say that, and then the brother was a director of the company. The brother sought to buy the land from the company for a certain price. His sisters approved, but they hadn't been told that a planning application had been made and that the architects were confident that plan permission would be granted. So consent was given, but it wasn't an informed consent. The sale then went ahead, and in due course the brother developed and sold the land at a profit. A number of years later, matters came to light, and the company sued the brother. So Lodges will see that the matters on the face of it are not dissimilar, in that a director self-dealt without informed consent and received the property himself, and it was for a purchase price. If I could invite the court to look, please, at paragraph 25. Your Lordships will note that in this report, we first have the judgment of the deputy judge, and then later in the same report we have the judgment of the Court of Appeal of this court. So it's at page 1199.
So you're looking at paragraph 25 in the Court of Appeal?
My Lord, yes. And I'll be inviting the court to look at various paragraphs between 25 and 29. Well, 25. Well, perhaps I could invite the court, first of all, to read paragraphs 25 to 27.
Yeah, I'll do that.
My Lord, the key part in paragraph 27 is the opening sentence. It follows also from the principle that directors who dispose of the company's property in breach of their fiduciary duties are treated as having committed a breach of trust, that a director who is himself the recipient of the property holds it upon a trust for the company. Is also described as a constructive trustee. And my Lord, that's reinforced in paragraph 29, where Lord Justice Chadwick said this: there is no doubt that Lord Justice Millett regards beyond dispute the director who obtained the company's property for himself by misuse of the powers which he had been entrusted as director was a constructive trustee within the first category. He referred to directs and other fiduciaries in that context. Then after the authorities, the reason is that a director on appointment to that office assumes the duties of a trustee in relation to the company's property. If thereafter he takes possession of that property, his possession is coloured from the first by the trust and confidence by means of which he obtained it. His obligations as a trustee in relation to that property do not arise out of the transaction by which he obtained it for himself. The true analysis is that his obligations as a trustee in relation to that property predate the transaction by which it was conveyed to him. The conveyance of the property to himself by the exercise of his powers in breach of trust does not release him from those obligations. He is trustee of the property because it has become vested in him. But his obligations to deal with the property as a trustee arise out of his pre-existing duties as a director and not out of the circumstances in which the property was conveyed. So, my lords, the key take...
I understand that, but to my mind, what's going on there is not focusing on the whole picture. I can see that at the point in time in which the self-dealing transaction takes place and the property is sold from the company, out of the company into somebody else, and whether it's Cambulo in our case or the facts of this case, at that point, I can see why it makes sense to say that the self-dealing fiduciary is holding the property on a constructive trust. But that's because at some point in the future, your clients effectively have the right to rescind the contract unless they've lost it, because you are able to get it back again if it could be got back again. And so in the interim period, the person holding the property, in this case like the director, is holding it on a constructive trust. But that's not the same thing as what happens when you affirm the transaction, because if you had rescinded the contract, you'd have had to pay the proceeds of sale back to the purchaser. And if you keep the proceeds of sale once you know that this has happened, then there isn't a constructive trust over the property anymore. The property was bought by the purchaser. What there is, though, I get, is a constructive trust over the profits that the director has made. But why does it make sense to say, once you've affirmed the transaction, that the property is being held on construction? You don't have the right to get the property back again once you've affirmed the transaction.
It's proprietary rights. Lord, it's well established from first principles, and I can certainly go back if need be, that where a director, for example, someone in the type 1 position, pre-existing rights, self-deals, he or she cannot take advantage of that, and therefore will hold them to the asset in question for the beneficiary.
Yes, but there comes a point where that stops the case, stops happening when you decide, and then once the beneficiary knows what's going on and has the opportunity to choose what to do about it, if the beneficiary exercises a right to rescission which it hasn't lost, then the director with the fiduciary who's a constructive trustee of the property will be obliged to hand the property back to the beneficiary. Completely with you there. But on the other hand, it isn't universally what happened, and it isn't what happened in this case, because your clients would have had to give the purchase monies back to Cambulo, which you obviously didn't do, which is fine, I get that. So at the point where you know that and the contract isn't rescinded, property isn't being held on a constructive trust. You can't have the property and the purchase price.
But my Lord, in our analysis at stage 2, Cambulo, as Mr. Ruhan's nominee, holds the property. Is a legal owner of the property, And for reasons we've said, it is on constructive trust. The HP2 is unaware, so there is no rescission.
Yes.
I agree that if analysis had been considered at that stage, if HP2 had discovered what had happened, it would then have it would be able to either effectively adopt or it could rescind.
Yes.
And if there was rescission, it would probably be on condition of returning the money, or there'd be a counterclaim for equivalent sum. But in the meantime, the property remains held.
Yes.
Can I understand what you mean by that? Do you mean that at stage 2, your client was the beneficial owner of the property?
Well, yes.
But that this may be look at J.J. Harrison. This may be an example of equity not putting everything together. But how can that possibly be right? You're the beneficial owner of the proceeds of sale, presumably. How can you be the beneficial owner of the proceeds of sale and of the hotels?
Well, the argument is probably best developed in the Foskett and McCowan, which was one of the other passages I was going to take your lordships to, as it explains in terms of tracing. If I can take your lordships
before you do, sorry. I know we're setting all sorts of hairs running that were not obviously raised in the skeletons, but we would like to get to the bottom of these things. Is it right that normally, if there's a self-dealing, the principal has the option to rescind?
Lord, yes.
And until rescission takes place, necessarily, it will not be the case that beneficial title vests in the principal.
Lord, with respect, no. This is trust property.
Well, it isn't once it's been sold, unless you rescind.
Lord, I think the answer is in Foskett and McCowan. Where you're considering trust property or the equivalent to trust property, which is the position of the director and assets owned by a company, if a trustee effectively does work on a trust asset, the principal has various options. But one, any work done on the property can be considered for the benefit of the trust.
Just before, so you're aware, as you go away tonight, think about any of these things, if you do, of the sorts of things I'm worrying about. Can I turn it round?
Lord, yes.
Now suppose that you had bought the hotels from from Camberloo, Madeira, and again Mr. Ruhan had concealed his involvement with that. What would you say the position would have been then?
My Lord, if perhaps you can repeat.
Yes, sorry. I'm now turning it round. So yes. Suppose that Mr. Ruhan had concealed his involvement in Camberloo, Madeira,
yes.
and Camberloo, Madeira had owned the hotels. And then he persuades you to buy the hotels at presumably an inflated price without revealing his involvement with Camberloo, Madeira. So you end up with the hotels, he ends up with too large an amount of money. What do you say with the position would have been in relation to that money?
Well, again, that's a clear breach of the self-dealing rule.
So you say the money would have been held on trust for you?
My Lord, yes.
Can you, in thinking about this, have a look at the line of cases stemming from Cape Breton, I think it's Cape Breton, Bentinck and Finn, is it called, which runs through to a case in the House of Lords called, I think it's Cavendish Bentinck, and then on to another House of Lords case, Burland and Earl. Because they don't obviously fit into this picture at all.
My Lord, yes. We'll certainly review those over. Well, perhaps I can then, to answer your Lordship's concerns raised just now, and turn to the question of Foskett.
Yes.
And that's at tab 24 in volume 3. then, friend, took your lordship to this case yesterday. The facts don't matter for present purposes, but in short, it involved a mixed fund, including monies into a life insurance policy. The relevant passage one finds at 1083. And it starts at the top of page 130. And one can see from, it's under the subheading and the tracing rules. The simplest case is where a trustee wrongfully misappropriates trust property and uses it exclusively to acquire other property for his own benefit. In such a case, the beneficiary is entitled at his option either to assert his beneficial ownership of the proceeds, or to bring a claim against the trustee for breach of trust and enforce an equitable lien or charge on the proceeds to secure restoration of the trust fund. He will normally exercise the option in the way most advantageous to himself. If the traceable proceeds have increased in value and are worth more than the original asset, he will assert his beneficial ownership and obtain the profit for himself. There is nothing unfair in it. The trustee cannot be permitted to keep any profit resulting from his misappropriation for himself, and his donees cannot obtain a better title than the donor. If the traceable proceeds are worth less than the original asset, it does not usually matter how the beneficiary exercises his option. He will take the whole of the proceeds on either basis. That is why it is not possible to identify the basis on which the claim succeeded in some of the cases. Both remedies are proprietary and depend on successfully tracing the trust property into its proceeds. A beneficiary's claim against a trustee for breach of trust is a personal claim. It does not entitle him to priority over the trustee's general creditors unless he can trace the trust property into its product and establish a proprietary interest in the proceeds. If the beneficiary is unable to trace the trust property into its proceeds, he still has a personal claim against the trustee, but his claim will be unsecured. The beneficiary's proprietary claims to the trust property or its traceable proceeds will be maintained against the wrongdoer and anyone who derives title from him except the bona fide post value without notice. The next paragraph, it starts off more complicated cases where there is a mixed substitution. And, my lords, perhaps we could skip down to just above H. The rule and its rationale was stated by Samuel Williston in The Right to Follow Trust Property. If the trust fund is traceable as having furnished in part the money with which a certain investment was made, and proportionate form of the whole money so invested is known or ascertainable, the Cestui Trust should be allowed to regard the acts of the trustee as done for his benefit, in the same way that he would be allowed to if all the money so invested and had been his. That is, he should be entitled in equity to an undivided share of the property, which the trust money contributed to purchase, thus a proportion of the whole as the trust money brought to the whole money invested. The reason in the one case as in the other is that the trustee cannot be allowed to make a profit from the use of the trust money if the property which he wrongfully purchased were held subject only to a lien. The amount invested, any appreciation in value would go to the trustee. And finally, at F on that page, in my view, the time has come to state unequivocally that English law has no such rule. It conflicts with the rule that a trustee must not benefit from his trust. I agree with Burroughs that the beneficiary's right to elect to have a proportionate share of a mixed substitution necessarily follows, once one accepts, as English law does, 1, that a claimant can trace an equity into a mixed fund, and 2, he can trace unmixed money into its proceeds and assert ownership. Accordingly, I would state the basic rule as follows: where a trustee wrongfully uses trust money to provide part of the cost of acquiring an asset, the beneficiary is entitled at his option either to claim a proportionate share of the asset or to enforce a lien as to his personal claim against the trustee for the amount of the misapplied money. And then the final paragraph at that page, 2 observations if necessary. First, there is a mixed substitution which, with the results already described, whenever the claimant's property is contributed in part only towards the acquisition of the new asset. It is not necessary for the claimant to show in addition that his property has contributed to any increase in the value of the asset. This is because I've already pointed out this branch of the law is concerned with vindicating that property and not with reversing unjust enrichment. My lord, In short, where a trustee acts wrongfully in relation to a trust asset, but it increases in value, the beneficiary is entitled to regard that work as having been done for the trust's benefit and take advantage of it.
I mean, the difficulty, I have to say, I don't see this as addressing the situations we've just been talking about. Because if you have an option to avoid a transaction but don't, on the face of it, the property which is passed out of your hands is not trust property. Therefore, you can't trace it. If you rescind, then plainly title revests in you and you can follow it. But if you haven't rescinded, then the property is not trust property. Now, that's not to say that you can't get an account of profits. It's not to say that the profits might not then be held on constructive trust, but that's not the same as saying that the hotels themselves are held on constructive trust.
Well, the position, as the judge found it, in a paragraph of his judgment which hasn't been appealed, is paragraph 271. It's in the core bundle at page 190. At 271, HP2 says that those profits are themselves trust property, being the traceable proceeds of the Hyde Park Hotel's Sultan Kambula Madeira in breach of trust. I accept that, in the absence of any defence of bona fide purchase of value in relation to the acquisition by the Kambula entities, the profits received from the on-sale of the Hyde Park Hotels are themselves trust property, in which HP2's existing beneficial interest continued, reference to Foxton. In these circumstances, as against Mr. Ruhan, those proceeds stand in the same position as the interest in the hotels did before them. It is well settled that a director who acquires the company's property in breach of fiduciary duty holds that property on trust for the company. There's J.J. Harrison. As Lord Justice Chadwick explained, this trusteeship is described as a constructive trusteeship. It is what has been referred to as the Type 1 constructive trust, because it arises by reason of pre-existing fiduciary duty owed to HP2, adopting Lord Justice Millett's categorisation in Paragon. If that is true of the hotels themselves, then I accept that is also true of their traceable proceeds in Mr. Ruhan's hands. Well, that's a finding that hasn't been challenged. Indeed, I think my friend accepted the gist of that.
I quite follow it hasn't been challenged, and I don't quarrel with the idea that the profits received from the on-sale, once you claim them as such, are trust property. We obviously haven't chased through all the possible authorities one could look at over lunch, but at the moment I'm not at all convinced by the idea that the beneficial interest of HP2 continued as owners, as the owner of the hotels. I would have thought that the trust arose in relation to the profits, not the hotels.
My Lord, yes, and I suspect, for my purposes, that's sufficient. And I'll move on to what I've described as stage 3 in a moment. Just completing the last point, it's a procedural point, not my favourite to take, but to reinforce what I said a few moments ago. If your Lordships still have the core bundle open, at tab 6, we have the
Core bundle.
The core bundle, my Lord, yes. It's page 95, tab 6. And we have Mr. Justice Foxton's judgment. Yes. And it starts off with a number of declarations. And perhaps I could invite the court to read first 5. Your Lordships have my point that those declarations aren't appealed. But I understand your Lordship's question is going to the root of the issue.
Yes.
Lord, I was going to my overarching points, and the other the first was my submission that one can say that HP2's beneficial interest in either the hotels or their traceable proceeds goes all the way through to the final stage. I appreciate that your Lordships have raised concerns in relation to what I've described as stage 2. And certainly overnight we'll review the authorities to which you've referred us. But for us on this side of the courtroom, the key stages are really stages 3 and 4. And my overarching submission here, and probably the key submission which we're making throughout this appeal, is this, and it's the ability to make a proprietary claim as at the stage that the proceeds of sale come in. So one considers what I've described as stage 3. Stage 3 is when Cambulo Madeira sells to bona fide purchasers in fact they came to the hotels in 2008, and £100 million odd comes into Cambulo Madeira. It's a point which we were going to be raising anyway, but my Lord Justice Newey raised it yesterday with my learned friend to consider this point. So imagine it's 25th of March, roughly £100 million comes into Cambulo Madeira. Rhetorically, what if HP had discovered this at that time? So the money is now sitting in Cambulo Madeira's bank account. When asked, my learned friend quite correctly accepted that HP2 would have a proprietary entitlement to that sum. And he quite correctly accepted that those monies were held in a constructive trust, indeed a type 1 constructive trust. The short point is, at a proprietary entitlement to that money, it's property. Property means property. So HP2 could have demanded its money back at that stage. It's found out that Cambulo Madeira has the money in account, and it could write to Cambulo Madeira or Mr. Ruhan as its principal, demanding its money back. Lord, imagine then that after making that demand for the return of its money, or after it's brought a claim for its money, Mr. Ruhan then dissipates that money. So HP2 is a proprietary claim, that's been accepted. HP2 makes that claim, and Mr. Ruhan then dissipates the money. Rhetorically, can it really be said that HP2 has suffered no loss? Immediately beforehand, it had a proprietary entitlement to, in this case, roughly £100 million. And then, thanks to the dissipation, it hasn't. Well, Lords, of course it has suffered a loss at this stage. Mr. Ruhan can't say, well, I did pay £125 million for the hotels 3 years ago, so there can't be any loss. Up until that dissipation, HP2 had a proprietary entitlement to £100 million odd. And, as my learned friend correctly accepted, and as a direct result of that dissipation, the entitlement is gone. Well, another way of...
Well, it still has an entitlement, doesn't it? It just can't get at the money.
My Lord, yes. The money's gone, but it had a proprietary claim to an asset. And then that asset has gone. So it's lost that asset. It's no longer traceable. My Lord, just stating that in summary form, as at stage 3, it's accepted that the money's in the account and HP2 had a proprietary entitlement and could have demanded the money back. Mr. Ruhan then dissipates the money. It may still have it will still have a personal claim. But that asset has gone. It suffered a loss. Put it in accounting terms. If HP2 had been quick enough on the date of discovery to instruct accountants, those accountants would have prepared a balance sheet showing an asset of £100 million. Then on day 2 after dissipation, they'd have to write it off. So HP2 had trust property and then suddenly it's gone. Well, taking the argument a little further, and again going back to March 2008, the Kensington Park hotels have been unsold for 100 million, and they've just been received into the account. And I've asked the court to imagine the situation as if HP2 demanded its money back. And I've said that asked the court to consider the position if Mr. Ruhan dissipates it. And imagine if he does so, but with Mr. Stephen's dishonest assistance. Lords, we submit it's clear and obvious, not only that HP2 has suffered a loss equal to the dissipated asset, but that the dishonest assister should be liable for any such loss. My own friend used the word amazing a number of times yesterday. We say that if it were the case that HP2 had a proprietary entitlement to £100 million on day 1, and then as a result of the wrongful dissipation on day 2, it has nothing. If it were the case that HP2 should be said to have suffered no loss, that would be amazing. It would also be artificial and absurd, wholly divorced from reality. And my Lords, just linking this to a point I'll be making later, we say that there's been a separate and distinct breach at this stage. And it's this separate and distinct breach which has caused HP2 to suffer loss equal to the funds dissipated.
I mean, I obviously follow the logic of that argument. But just thinking around it for a moment, it's right, is it, that at the point that the profits come in, they are still only held on trust if you elect for an account of profits.
My Lord, this is before any election. The reality is elections don't usually take place at
No, I see that. I mean, suppose at the later stage you opt for compensation instead. What's the position then?
Well, at the time that the money is still in the account.
We're at the point at which the money is, well, the money is in the account. Now we know that actually you opted for compensation in respect of the totality of Mr. Ruhan's breach of duty. Was the money held on trust for you at the point that it came into the account?
Lord, up until any election, it's held on trust. And the beneficiary has various options it can elect. One route would be to claim the property. That's the equivalent of an account.
It's not equivalent of an account of profit, though.
But my lord, the simplest thing is simply to demand its own property back.
Yes, but
So
the point,
is-
as we put to you by my lord and me a few times, if you had elected to take the property back, you'd have had to pay Campbell 125 million. You don't get the money and the property.
My lord, that's at stage 2. That would have been the case. At the time of the sale to Cambulo, if at that stage the property had been sold for £125 million, and absolutely, if at that stage we discovered and we wanted to rescind, it would almost certainly be invariably on condition of return £125 million. The property between 2005 and 2008 went up considerably in value. For various reasons, passage of time and planning permission, and generally the work which was done by constructive trustees, amongst others. And this goes back to my Foskett point, that the beneficiary is entitled to regard this work as for the benefit. Usually an allowance will be provided. So my lord, if for example I'm the beneficiary of £100 and the trustee takes it and does some work on it, and a few years later that £100 worth £1,000, I can regard the good work that the trustee has done as for the benefit of the trust, and I can take the full £1,000, subject usually to an allowance for expenses and work done by the trustee. So in this case, over the 3 years, in fact, between 2005 and 2008, work had been done, passage of time, and the monies which came in were the profit taking into account the £125 million. My lord, so at that stage that one can forget the 125.
But I understand that, but just getting to that point, the point that my lord asked you about, which would help me as well, if I could just try and put it to you again, is there's something slightly inchoate about these trusts that you're talking about at that stage, because you still have the option later, when all is revealed, your clients can still elect, and let's say for the purpose of analysis that they elect not to pursue their rights as beneficiaries of trust property, but to take compensation for loss in the conventional sense of loss instead, and in which case it's right, isn't it, that for at least going forward, would you accept that the property is no longer held on trust? Because what you've chosen to do is affirm the sale contract and take your chances, as it were, for the losses that you've suffered. You're entitled to do. You may say it would be economically bonkers on the facts of this case. No doubt it would, but that's not the question.
Look, there are two different things.
That's right. That's right, though, isn't it?
Look,
It wouldn't be a trust in future if that was the election that you took.
Well, Lord, yes.
Yes.
Well, that's correct. Obviously, in terms of an election between account of profits and equitable compensation, that's something which the person bringing the claim rarely has to decide. In fact, in this case, it was post Mr. Justice Foxton's judgment that we
Sure.
had to make the election. But your Lordship's analysis with respect is absolutely.
But that is an oddity, because Mr. Justice Foxton has found that Mr. Stevens is liable for the loss of the Type 2 trust property, which was held on trust, in circumstances where it wasn't yet known whether there was going to be a trust at all, because if you'd opted for compensation, the trust wouldn't be there.
Well, it wasn't a Type 2 trust, it was a
Type 1 trust, sorry.
Yes.
But at the point, there's judgment against Mr. Stevens for the loss of the property held on trust when you don't yet know whether there's going to be a trust, because you haven't made your election.
My Lord, until there's been an election, the property is on trust. The J.J. Harrison and indeed Gwemby and the other authorities make it clear there is a trust. In the circumstance which my Lord Justice Birss described, that can come to an end. But that didn't happen in this case, or I suspect in most cases, the property remains trust property until there has been an election. In this case, it was the hotels, even when held by Kambula, we would say. But more importantly, at stage 3, when the proceeds come in, net, effectively, these are the net profit. Those are traceable proceeds of the hotels and held on type 1 trust, because Mr. Ruhan had pre-existing duties in relation to the original property which could be traced through. So as at the stage they're in the bank account, they are on trust, held by Kambulo, Mr. Ruhan's nominee, for HP2.
I ought to shut up. I would have no trouble with that sort of analysis if Mr. Ruhan had simply pinched the money. Then you could simply follow the money through. But here there was originally a contractual transaction, which on the face of it means that unless and until you rescind, and you obviously aren't going to, property in the hotels has passed. That doesn't mean you won't get a constructive trust, because you're entitled to an account of profits and a constructive trust going with that, if you choose. It's not so obvious that you can complain about breach of that trust prior to you making your election.
Well, look, I go back to the analogy with the example I raised 10 minutes or so. That when the money, stage 3, the money was in Kambulo's account, HP2 had an entitlement to that money at that stage. As my learned friend quite properly accepted yesterday in answer to your Lordship's question. Then Mr. Ruhan, and so while the money was there was an asset which was traceable, and HP2 had a direct proprietary claim to it. But then effectively he did dissipate the assets for his own ends. In fact, they went on money on the Qatar project in a way which was wholly untraceable. So HP2 suddenly had lost that.
Yes.
So, Lord, as I say, in terms of stage 2, certainly the way we understand J.J. Harrison, and with respect how the trial judge understood J.J. Harrison and the other cases, was that the properties, the hotels were still held on type 1 trust. But undoubtedly, at the time the process of sale came in, that undoubtedly, as being said by my friend, were held on trust. So we had a claim there and then. And Lord, what this comes down to, essentially, is that if we had a claim as at stage 3 for the monies in the account, which we undoubtedly did, and Mr. Stevens dishonestly assisted, which it was found that he did, and there's no challenge to that, we say that caused loss. And the ultimate question, which my friend asked you to take on board, is to consider whether you compare the position as a whole, considering the counterfactual, or whether it's possible simply to look at that.
Yes.
We say it's very simple. As at March 2008, 3 years, many years after the self-dealing transaction, we had an absolutely slam dunk, to expression, an entitlement to recover property. And then that property disappeared. We say in no real world can it be said we didn't suffer a loss. On day 1, we had an entitlement to £100 million in cash, and day 2, that money's gone. That's a very real loss. A lot of
We're asked for 2 minutes, so we'll break for 2 minutes.
all right. That's fine. Not at all. Core eyes.
Mr. Pickering.
Very fine. My lords, I was taking your lordships through a number of the authorities. I've taken your lordships to Paragon and J.J. Harrison.
Yes.
My lord, if I can deal with Gwembe, which is a case my learned friends have referred to. In short, we say it's a completely different type of case. It's a tab 31, which your lordships will find in volume 4. Page 1273.
Yes.
My lords, in summary, this involved a joint venture in Zambia, and the vehicle for the joint venture was the company. And one of the directors of the company was Mr. Koshi, who was the majority shareholder in a company called Lasco, which was the largest investor in the company. Mr. Koshi then arranged various loans of money from Lasco to the company. But by taking advantage of Zambia's foreign exchange restrictions, Lasco was able to make a considerable profit out of the loans. In due course, matters came to a head, and there are various issues at trial, including limitation. My lords, as for the fine of the first instance, one can see that the head note at 1275, subparagraph 3, towards next to little g. The trial judge was entitled to refuse to make an order. Apologies. It's at page 1273. We can see at the bottom of 1273. On the 15th of November, it's about 6 or 7 lines up, 1996, the company, by its receiver, brought an action against Mr. Koshi and Lasco, claiming an account of profits, etc. The second from bottom line, a declaration was also sought that Kay and Lasco were liable as constructive trustees of all the company's money received by them. The trial judge 1 dismissed the company's claim that Kay was liable as constructive trustee. 2, dismissed the claim against Kay for equitable compensation for dishonest breach of fiduciary duty on the ground that no loss was proved by the company to have been caused by the breach of duty. 3, held Kay liable to the company for an account of profits made by him from the pipeline loan transactions on the basis of a breach of the no-profit rule by dishonestly using his position as managing director of the company to procure, in his own interests, rather than interests of the company to enter into the pipeline loan transactions, while deliberately not disclosing to the other directors and to the shareholders of the company his controlling interest in Lasco and the scale of the intended profit from the transactions. And we can see just above letter E, the company appealed against the form of the order for an account of profits and also the refusal to award or direct an inquiry to assess equitable compensation for loss caused by the dishonest breach of fiduciary duty. My Lord, the summary of what the Court of Appeal found, one can find at 1275, subparagraph 3. The trial judge was entitled to refuse to make an order for payment of equitable compensation by Kay, or to order an inquiry to assess such compensation on the factual basis that he was not satisfied that loss had been caused to the company as a result of the breach of duty by Kay, by non-disclosure of his personal interest in the pipeline loan transactions and the unauthorised profit made by him from the transactions. The appropriate remedy for non-disclosure was to make Kay account to the company for the profit, and is not appropriate if the company so elected to require him to compensate for the company for loss suffered in a joint venture when it was probable that the disclosure by K of his interest would have made no difference to what the company would have done. Accordingly, the company's appeal against his refusal to make such an order would be dismissed. Lord, so the breach relied upon was the director's failure to disclose certain matters to the company's shareholder relating to the transaction. And the claim was for the unauthorised profit which the director had made arising out of the loan transactions. My Lord, one can see immediately here that this is a type 2 case. In J.J. Harrison, the property which was self-dealt had been the company's, and then after the transaction was the director's. So the director recipient had pre-existing responsibilities for the property before he bought it. Same for our case. Type 1 case, it's a classic misappropriation of property. Mr. Ruhan was a director, trust-like responsibilities towards the hotels, and then Cambulo's nominee bought the property, bought the hotels. In this case, the profits came from a side transaction. Mr. Koshy exploited his position and was able to make profits from a transaction. And that money came in. So there's no pre-existing property, there's no pre-existing trustee-like responsibility. The money came into him, and for the reasons that Lord Justice Millett explained in the Paragon case, equity imposed upon him a constructive trust. It's not really a trust at all, but imposed upon him a constructive trust. Not like a true trust. So it's immediately different in that sense. My Lords, there are various passages to which I'd refer the court. And where I'm going with this, of course, is this is a case in which my learned friends rely. They say it's a similar case and there's a different result. We say it's a completely different case. My Lord, 1305, page 163 of the report, under D we have a reference to the judgment below. I'd invite the court to read 113. And perhaps the court could bear in mind, as your lordships will see later, it turns out that what the judge says is incorrect. But perhaps your lordships could read 113.
Yeah.
Sorry, I missed the reference.
It's page 1305 of the bundle, and it's paragraph 113. Your lordships will see the reference to what Mr. Justice Reimer has said at first instance. And the final sentence, the trial judge concluded, I cannot see how they can have been received by him other than as a type 1 trustee. With respect, that's wrong, and the Court of Appeal find that's wrong, because the profits didn't exist before the transaction in question. We then turn to the arguments in the Court of Appeal at 1306, or page 164. And we see...
Just let me just catch up, sorry. The point is, so what's wrong is the idea that the profits are held under a type 1 trust.
My Lord, correct. Thank you. They're held under a trust, but it's a type 2. 1306, we have the arguments in the Court of Appeal. And at 118, as there is a risk of the detail of the arguments obscuring the real issue, some preliminary observations may help to clarify the position. The company's cause of action against Mr. Koshy were not and did not need to be based on either knowing receipts of trust property or on dishonest assistance in a breach of fiduciary duty, being claims usually made against third parties, and claims of the kind recently considered by the House of Lords in Twin Sector. The claim against Mr. Koshy concerned the personal liability of the fiduciary himself for breach of duty, not the third-party liability. 2. Mr. Koshy's personal liability to account to the company for profits made by him for his fiduciary position as a director is not dependent on establishing that he has received any money in other property. Again, that's clear. A bit further down in that same paragraph, the company's causes of action against Mr. Koshy were based on equitable disabilities or the fiduciary duties to which he was subject as director of the company. As such, he was under a personal liability in equity to account to the company for unauthorised profits, either because he was disabled in equity from making an unauthorised personal profit out of the position occupied by him, and or because he acted in dishonest breach of fiduciary duty by deliberately and secretly doing so. And my lord, the next sentence is important, I would say. The profits made by him are treated as taken for and on behalf of the company, as the person to whom he owed the duty to account. As between him and the company, equity prevents Mr. Koshy from asserting, in answer to the claim for an account, that he is entitled to retain the profits, if any, made by him for his own benefit. Well, Lord, I think we can skip over the next few sections until paragraph 119. If that is the correct analysis, then it's clear in our view that any trust imposed on Mr. Koshy is a Class 2 trust within Law Justice Millet's classification. We agree with the judge that liability to account for unauthorised profits may arise within a wide spectrum of factual situations. However, that does not alter the analysis under Section 21, each of which must be applied in accordance with its own terms. We disagree respectfully with the judge in treating dishonesty as a factor, taking the case from Class 2 to Class 1 for the purpose of Para B. Nor do we think that there is effect of the passage from Lord Justice Chadwick's judgment in the Harrison case, quoted by the judge. As the judge recognised, in that case the director transferred to himself property which had previously belonged to the company, and in relation to which he had trustee-like responsibilities before the transaction in question. By contrast, Mr. Koshy's liability to account for undisclosed profits and any constructive trust imposed on the profits did not depend on any pre-existing responsibility for any property of the company. They arose directly out of the transaction which gave rise to those profits, in the circumstance in which it was made. The fact that Mr. Koshy was in a pre-existing fiduciary relationship with the company was not enough by itself to bring the case within Class 1 any more than it was in Taylor and Davis.
Could it not be said that there is something similar here? It may be that there was a Type 1 trust of the hotels before they were sold at stage 3, but once they are sold, a new trust of the profits comes into existence, which is a Type 2 trust because you never held or had any interest in the profits. Is that the argument against you?
My Lord, with respect, no, because the proceeds are the traceable proceeds. My Lord, if there had been a separate opportunity and separate profits which hadn't existed before came in, they would be held on a Type 2 trust. But the hotels had belonged to the company. After transfer to Cambulo, the self-dealing still held. When they are sold, their proceeds of sale were directly traceable. That's uncontroversial. And because it's the traceable proceeds of the hotels, it's still, to use Lord Justice Millet's tracing analysis, it's still effectively, we still have the same proprietary rights. If you're a beneficiary and you can trace through, you still have a proprietary right insofar as you can properly trace.
Because if you were tracing, in a really simple case, take a really simple example. The fact of this case, only at the point that Cambulo sell the hotel, that we know, never mind all the complication of the joint ventures, we know that they sell the hotel 320 million. In a tracing claim that you were bringing against Cambodia in that case, you would get the 320 million. You wouldn't just get the profit, you'd get the whole thing. The proceeds of sale are not the profit. So the proceeds of sale are the whole proceeds of the sale. It's not the same as the profits. The profit is part of the proceeds of sale, but it's not the whole thing. But you only get the proceeds of sale if you're asserting your claim to the property. But for that, you have to rescind the contract.
With respect, we don't need to rescind the contract. When the hotels are sold, the hotels go to bona fide purchasers for sale, equities darling. So we can no longer follow, I should say, the hotels. But the proceeds of sale are directly traceable.
Yes, but that's not 94 million, that's 320 million.
Well, look, that's 320 million pounds. And in relation to that, then some of it goes to the candidates who we have to accept for these purposes of bona fide purchasers, and therefore we lose our tracing claim for that. What's left? It's certainly not all of the proceeds of sale, but the 94 million pounds represents what's left, and we can still trace into that. The Lordship's absolutely right that in an ideal world, 320 million pounds would have come in, and we would have tried to attack and claim our entitlement to all of that. In fact, we weren't aware of it. But if we had been, the candidates would be able to say, well, half of that, or roughly half of that, is ours. And as bona fide purchase for sale, they would have taken it. So that's absolutely right that in a simple case, we would have a tracing claim to all of it. But in fact, we have to accept that some of it went to various equities and equities darlings. The 94 million pounds is what's left.
But it's only a tracing claim if you're asserting your claim to the hotel.
Well, yes.
But you're not asserting your claim to the hotel. You're asserting your claim to the secret profit earned by the fiduciary for self-dealing.
Well, with respect, no, we've always maintained a claim for the property.
But if somebody said, but if you wanted to get the property, you'd have to give them back the 125.
My lord, with credit, but that credit's been effectively taken into account in the proceeds of sale.
But I'm about to say at the moment, I'm not convinced that it's a trace. I know you keep going on about it. Forgive me, sorry, Mr. Cooper. I know you keep saying tracing claim. I know you say that. But I'm sceptical that what in fact your client is doing is to be analysed as a tracing claim in the circumstances as they now are. Just to be absolutely clear, I'm not in the slightest doubting your client's right, as against Mr. Ruhan, for him to account for the profit that he made from his breach of fiduciary duty. I'm completely comfortable with that, but I'm sceptical that analysing this in the context as a tracing claim is helping. It's certainly not helping me, I tell you. Because to me, a tracing claim is all about your right to recover the hotel, but you're not asserting your right to recover the hotel.
Well, Lord, that's because the hotels have gone.
Well, maybe we don't know what the reason is. You're still not asserting your right to the hotels, because what you're asserting is your right to the secret profit, the account of the profit. Well, as soon as you, because I haven't understood why, and I know I keep coming back on it, and I'm sorry I'm not in all the record, but every time you're saying you're asserting your right to the hotels, I say to you, what about paying back the 125 million? And you always tell me it's taken into account, but then you still say you're asserting your right to the hotel, and it doesn't make sense to me. I'm sorry.
I understand your Lordship's concern. I think the key point on which we invite the court to focus is what is undoubtedly the case, is that when the proceeds of sale came in, there was a trust, that happens to be a type 1 trust. That's been accepted. That was found by the court below. And indeed, my own friend accepted that was the case yesterday. So Cambulo received proceeds of sale. It originally received some £320 million. It paid off various bona fide parties, what was left was £94.5 million on. And it was accepted at trial, it's found at trial, and it's accepted yesterday that that money was held by Kambula on constructive trust for HP2. So we had an entitlement at that stage to those monies, and then those monies were dissipated, which represents the loss. Lord, we could have asserted an equitable compensation claim against Mr. Ruhan. It would have come to the same thing at that stage. If after the dissipation his use of £94.5 million, we could have asserted a claim against him. It made no difference, in fact, whether we elected, in his case, for an account of the profit, because he had made a profit of £94.5 million from it, or he had caused a loss because the company had constructed trust, trust property means property, and he had dissipated it. So for
sorry, but I think this is an important point. You say it made no difference because you could get the profit as a profit, or you could complain that he had dissipated property that was held on trust for you.
Well, yes.
But it was only held on trust for you because you claimed the profit.
Lord, absolutely. But then it was lost because he dissipated. He spent it in a way so it became untraceable.
But that, I suppose this goes to the heart of the case. It seems odd that you can say, look, it's held on trust for us because we're claiming the profit. But then say, no, we're claiming compensation. So
in order to claim equitable compensation, you would have had to face and surmount the argument which Mr. Stevens raises about separate and distinct.
Lord, yes.
If you made that claim against Mr. Ruhan,
My Lord,
which
yes.
you don't have to do for the account of profits claim.
Lord, yes.
So just to be clear, it's not merely, as the judge wondered, whether you're enlarging the liability of the assister by adopting the approach that he thought was probably right, but that it really doesn't matter whether you claim an account of profits or compensation against the fiduciary, because it will come to the same thing.
Well, in this case, yes. My Lord, the passage in Patel, my learned friend took you to a reference to it in Professor Worthington's article. Perhaps I can take your lordships to Patel itself. There's a passage I was going to take your lordships to in any event. Patel, your lordships will find it's at tab 51 in volume 7. Well, this, I hope, will go some way to answering your lordships' question.
Can we leave Gwen Valley, or are we coming back to that?
My Lord, we can leave it.
Thank you.
It's tab 51. It's a very short passage. It's paragraph 31 at page 2683. But I think it's useful because it does help, I think, answer your lordship's last concern. Paragraph 31. Equitable compensation is the personal remedy, as opposed to a tracing proprietary remedy, available against trustees or others in a fiduciary position whose acts or omissions amount to a breach of trust or fiduciary duty. Breaches of duty may take many forms, but in broad terms they are often with good reason analysed as falling within one of three main categories. First, transactions involving the unauthorised payment or disposal of or damage to trust assets, causing loss to trust. Second, breaches of duty of loyalty involving the trustee making profits at the expense of the trust or by the use of information or opportunities available to the trustee. Third, breaches of duties of skill and care, resulting in loss of the trust. So working backwards, the last one is the want of care. So if one's a trustee and you, for example, invest badly. The second one is breaches of duty of loyalty. So this is the Gwembe case, where someone uses an opportunity and they make a profit which didn't exist beforehand. They've made a profit from their opportunity or from the information, and that brings in property which didn't previously exist. It certainly wasn't previously owned by the company, but it's held on constructive trust, classic type 2. But the first, transactions involving the unauthorised payment or disposal of any damage to trust assets. So you're actually dealing with trust property, a misappropriation. So if, for example, there's £1,000 in a trust and the trustee takes £100, Gwembe clearly is in the second category. The present case is in the first category of cases.
I have to say, I find that very difficult to accept.
Well, my lord, if I can use a simple example, the hotels. If, for example, Mr. Ruhan had just stopped taking the hotels for himself, transferred them to himself for no value, that's not the case here. That would be a misappropriation, has taken trust property. What in fact happened here, he bought them for a value. They're then on sold, and proceeds of sale come in, which it's accepted. It was found by the judge and accepted by my learned friend. That is, those are the proceeds of sale. That's trust property.
So can we just pause there before we get on to your later trust? Is it at that stage a misappropriation case?
Lord, yes, because it represents what had been the company's property.
But you've sold it.
But it was in breach of the self-dealing rules, so it's held on trust.
Because that means it was in breach of the duty of loyalty.
Look, the distinction is whether an asset comes in which didn't previously exist. So, Lord, yes, there is a breach of duty of loyalty. That's part of it. But
well, isn't it all of it? I mean, if there weren't a duty of loyalty, there wouldn't be a problem.
Well, my lord, the difficulty with loyalty is, as your lordship said, loyalty covers everything. But in terms of the categorisation which is used in the Patel case, the question, the key category 3 is quite clear. That's want of care. It's a difference between looking at something which comes in or a profit which is made which didn't previously exist. So one has an opportunity. So in the Gwembe case, Mr. Cushy used his position, arranged loans, and a profit was made which didn't previously exist. That's held on trust. That didn't previously exist. Clearly a breach of loyalty, and in category 2. If he had actually taken money, that was category 1. Now in our case, the hotels case, the hotels have been sold and there's that money there. So it's a depletion of the original trust asset. And Lord, going back to the question your lordship raised, in our case, suing Mr. Ruhan, or indeed anyone with a category 1 type of breach, an account of profits and a claim for equitable compensation would amount to the same thing. So, for example, test it this way, a very simple case. There's a trust fund of £1,000 and a trustee steals £100 and this is completely gone. An account of profits, well, he's taken a profit of £100. Equitable compensation, the loss, it's £100. So in that situation, where a breach of trust involves a depletion of assets, it will invariably be the case that an account of profits will be the same as equitable compensation that the loss suffered.
That's not really a profits case, is it? He's simply stolen £100. He's not made a profit from that £100, at least in what you've said so far, for which he is now being asked to account. He's just a thief.
My lord, that's another way of putting it. But the point is, one can ask for an account of what gain has been made. We'll look up for a second. Lord, I think the other way to exemplify it is to, I keep going back to it, it is key to our arguments. It's one can imagine at stage 3, the money's in the account, and we are quick enough, didn't happen on the facts, we're quick enough to catch them with the money. We could have sued for the return of that actual money at that stage. So in this situation, Mr. Ruhan has actually made £94 million odd. And so that's one way of looking at it. But also, there is a trust fund there, which we can claim. After we make a claim for it, or even before we make a claim for it, he disposes of it. So suddenly, that cash, that asset to which we had an entitlement, has gone. That's a loss. And he's paid no value for it. And we're going back to the balance sheet point. If on that day 1 we have the cash in our account, so the cash is in Kambula's account, we're quick enough to instruct accountants, and they say we have an asset of £94.5 million. Mr. Ruhan then takes the money, so that's gone. And it's true that it's our case that we now have a claim for equitable compensation against Mr. Ruhan to an equal sum. That's because it's a claim against Mr. Ruhan. That reinforces our case. But the point is that we have lost an asset. It simply disappeared. And my lord, unless there is a comparable claim against an equivalent claim against Mr. Ruhan for £94.5 million, we've simply £94.5 million has simply disappeared. That can't be right. That can't be right. Lord, I was making some overarching points, but as I indicated earlier, and I think as we discussed a few moments ago, I think the key to this case is the next part of my submissions, which is where my learned friend talked about there being separate and distinct claims.
Yes.
And well, in this section, what I propose to do is to consider, first of all, relevant principles. Secondly, to consider the application of the principles to the facts of the present case. And then, thirdly, to consider the judge below's particular reasoning. And as to where this is going, the Lordship's beware, my learned friend says that he accepts that if one looks in isolation at what happened at what I've described as stage 4, so the money's come in at stage 3, Mr. Ruhan takes it. If one looks at just that in isolation, then there is a loss of £94.5 million. He accepts that, he has to. But he says one cannot look at it in isolation. One has to look at the counterfactual. And the counterfactual, he says, is to go back and look at what would happen if none of this had taken place. And when we go back to the position, go back to stage 1, before the self-deal. That's the real issue between us. Because if he's right, then he will succeed on ground 1. If I'm right, I think Mr. de Garrelson has to accept, he has accepted, I think, that in isolation, there's been a loss and suffered. Lord, in terms of the principles, perhaps I could go back to the case of Bartlett. It's tab 8, which I think is in bundle 1. It's a page 255 of the electronic bundle and page 538 of the law report. Now, your Lordship will recall this case. My little friend took your Lordship to the facts yesterday related to a case where a loss had been suffered in one transaction, and the question is to what extent an earlier gain could and should be taken into account. But we're dealing with the general principle here, and Mr. Justice Brightman, with respect, quite correctly sets out the general rule, that is what it is, at 538C. The general rule, as stated in all the textbooks with some reservations, is that where a trustee is liable in respect of distinct breaches of trust, one of which has resulted in a loss and the other in a gain, he is not entitled to set off the gain against the loss unless they arise in the same transactions. And reference is made to Halsbury, Snell, Lewin, and Underhill. The relevant cases are, however, not altogether easy to reconcile. All are centurions, and your Lordships have seen the rest which deals with the particular facts. But the short point is, this is a useful summary of what is the general rule. And if I may respectfully agree with, well, we then have the actual decision itself. And your Lordships will recall the particular what happened in this case, and your Lordship will recall how Lord Justice Brightman considered that in this particular situation account should be taken of the earlier transaction. It was a very short passage, and as your Lordship, if I can respectfully adopt my Lord Justice Newey said yesterday, it's hard to extract precisely what the dividing line is. Where we do get more guidance is from the case of Brown and KMR Services. That was a case which was referred to by Mr. Justice Foxton. My Lords, this unfortunately didn't reach the authorities bundle. Perhaps I can hand out some copies. And my Lords, if you could also have open the judgment, the core bundle at page 194. There's a useful summary of the facts, and I can do no better than to refer to that. It's a paragraph 279.
So we should just look at that, should we?
If your Lordships could just read the opening part of paragraph 279. But in terms of the key passages themselves, we have the first judgment is the dissenting judgment of Lord Justice Stuart Smith. And perhaps I could invite the court to look at page 621. At the bottom of the page, one can see a credit for the profitable years. And His Lordship asked the question, should credit be given against the damages for the profits made on high-risk syndicates in 86 and 87? In his second ground of cross appeal, Mr. Hamilton contends the judge was wrong to give such credit. And perhaps I can invite the court to read 622 down to F.
Yes. Yes.
My learned friend yesterday referred to having one's cake and eat it, and here it's the plums and leaving the duff. But it's the same principle which was argued against me yesterday. That was the dissenting judgment. And we then at 623 have the judgment of Lord Justice Hobhouse, part of the majority. I could invite the court please to look at 640. And perhaps I could invite the court to read under the subheading set off for earlier years, the 640C down to 641H, so the almost 2 pages.
Yes. Yes.
So my Lords,
And Lord Justice Peter Gibson obviously agrees with Lord Justice.
my Lord, it's a very short judgment at page 645.
Yes.
What one can see from the Lord Justice Hobhouse's judgment, first of all, there is a general rule. It's also absolutely right, there are exceptions. There are exceptions when the cause of action are not separate and distinct. And Bartlett is very much a unique case, decided on its particular facts. And as your Lordship will recall from the passage, it was a very short passage from the judge in Bartlett, which doesn't actually give much guidance as to where the line should be. But Bartlett was very much a unique case, deciding its particular unique facts. And Lord Justice Hobhouse gives us a really stark warning when he refers to, this is back at 640 J, the judge may have thought that he was doing some higher justice, but who is to know whether that was in fact the case? And effectively he's saying one can open a can of worms, and the answer is to, in fact, look at each cause of action, unless they really can't be said to be separate and distinct. My Lord, perhaps the most useful summary of the position is in Underhill. My own friend did refer to this yesterday. It's tab 76, so in volume 9. I only would need to refer your Lordships to three very short paragraphs, but they provide a neat summary of the position. 93.1, a trustee is liable only for the actual loss in each distinct and complete transaction which amounts to breach of trust, and not for the loss in each particular item thereof. Loss in one transaction or fund is not, however, compensated by a gain in another and distinct one. Then reference is made in 93.2 to Bartlett and Barclays, and there reference is made to the general rule, distinct breaches of trust, not entitled set off. And then in 93.5, there is scope, however, for trustees to escape the consequences of the no set off rule by arguing that their actions have all formed part of a single transaction. I'd invite the courts to focus on those words, a single transaction. Moreover, their scope for making this argument may have been widened by judicial acceptance of the principle that trustees may adopt a modern portfolio investment policy in accordance with which the pursuit of a total capital income return is regarded as forming part of one transaction. So, my Lord, what we can see from Bartlett and the Brown and KMR services, and indeed summarised by Underhill, is there is a general rule. The general rule is that one can consider each distinct and complete transaction which amounts to breach of trust. So it's not separate and distinct, which suggests there must be some difference. The test is whether it's separate or distinct. There's two different ways of saying the same thing. It's a language game otherwise. There can be no set off unless it can be considered all form part of a single transaction. And my Lords, in a nutshell, I would respectfully suggest that this appeal, or at least Ground 1's appeal, comes down to this question. What can be considered all part of a single transaction? The general rule is that each separate cause of action has to be considered by itself. If that's the case, one simply looks at my stage 3, stage 4, money comes in at stage 3, and at stage 4 it's taken out. That in itself causes a loss. My learned friend, that's applying general law, says, well, no, it's all part of a single transaction, and one needs to look back to 2005 and the self-dealing transaction and consider everything as a whole. So the question is, can what happened in 2005 all the way through to 2008 be considered as part of a single transaction? So those are the principles, and I propose now to consider them in the context of our case. Starting point is, are they separate or distinct causes of action? And the short and uncontroversial answer is yes. My then friend accepts this much quite quickly. The distinct cause of action, on the one hand, we have the proprietary claim, we have stage 3, the money in the account, which is being dissipated. We say that's obvious that the dissipation then gives rise to a cause of action. That's not in dispute. So that's the starting point. And the question is, can the second defendant get within the exception by saying it's all part of a single transaction? So I would invite the court to consider what precisely my friend is inviting the court to find. The self-deal which took place in 2005, and the dissipation of assets via the mood facility in 2008, it's all part of a single transaction. In fact, my friend has to go further than that because of all that's happened in between. So he'd have to say that everything which took place from the 2005 self-deal all the way through, leading to the dissipation, stage 4, all part of a single transaction. Lords, we say it's absolutely plain it's not a single transaction. Another way to put it, it cannot realistically be said that the dissipation at stage 4 is simply the other side of the same coin as the self-dealing at stage 2 way back in 2005. Your Lordships, one can readily see the sort of cases where one can say it's part of the single transaction. Reference was made in Underhill to a portfolio situation where you have, one can readily understand that. In Bartlett, reference was made to common sense. Indeed, sometimes the process is maybe slightly intuitive. But with respect to my own friend, to suggest that the self-deal in 2005 and all that happened in between, the on-sales in 2008 and the dissipation via the mood facility, is all part of a single transaction, we say that would be amazing.
Is it right that because of the way this point arose, the judge never actually set himself this question, i.e. single transaction? I mean, he's looking at whether they are separate causes of action, which is a prior point, but it doesn't look as if he actually posed this question to himself, so we've got to answer it for ourselves without the benefit of his view about it. Is that right?
Well, my lord, the authorities use the expression separate and discrete causes of action, that they can be seen to be separate and distinct. And indeed, that's in particular in Lord Justice Hobhouse's judgment in the Brown and KMR. Underhill refers to a single transaction. It's another way of saying the same thing. In fact, Lord Justice Brightman in the Bartlett case refers to separate and distinct.
No, I'm not asking about that. I'm simply asking. I can't see anywhere in the judgment where the judge asked himself this precise question that you're now addressing us on, i.e. was it a single transaction throughout from 2005 to 2008, or were they different transactions? Am I right in thinking that the judge did not set himself that particular question?
Lord, your Lordship is right that he didn't use the word single transaction. He didn't ask himself that question, but he did consider whether there were separate and distinct causes of action.
Yes.
So your Lordship is right.
Yeah, That's all I was asking. Thank you.
Yes. But in terms of what the general rule is, the authorities refer to separate and distinct, and that is the question which the judge asked himself. We say if one just steps back to use the common sense test, it would not be in accordance with common sense to suggest that this is to use either formulation, either that it's a single transaction. It's clearly not. Nor can it be said, so clearly they are separate and distinct causes of action. And of course, it's effectively, because of the general rule, it would have to be shown that, that these are not separate and distinct. We say, just stepping back, it would be artificial, and it doesn't make sense to consider these as anything other than separate. It's right that the same players were involved. There's a significant time difference. We accept that in itself is not determinative. But so many intervening events and so many different things which could have happened. It's not a portfolio type case, which could be said to be the justification for the Bartlett case. Then a friend referred previously to target and those kind of cases and artificially stopping the clock. That's of course well established. There are different types of cases, but that principle is well established. And the complaint there was that parties were trying to artificially stop the clock. So they were moving forward and wanted to stop the clock and not look at what in fact happened afterwards. What my learned friend is trying to do is something different. He is saying that we are starting the clock halfway through. But with respect, that's wrong. We have a clear cause of action at the point of stage 3, as my new friend has to accept. What he is trying to do is artificially go back in time. To go back to what Lord Justice Hobhouse said, if you open to paraphrase, opening a can of worms, well, how far do you go back? Should we go back to before the self-dealing transaction? Are there other matters which ought to be investigated? Unless it's, to use another expression, the other side of the same coin, you don't do that. It's artificial to go back in time. There's a simple cause of action here, and that's all we need to look at. To go back further is artificial. What my lady friend is trying to do is effectively ignore clear property rights, a clear proprietary entitlement. We had property, and then it was gone. In any event, it's not a single transaction, it's as simple as that. Look, the final matter to which I'd address the court in this section of my submissions on separate and distinct cause of action is to look at the judge's reasoning. And as a preface to that, my lady friend said yesterday, you don't have to turn to it, but your lordship's notes at page 51 of the transcript. My lady friend said, it's wrong in my submission to do what Mr. Justice Foxton did in this case, to just say, excuse me, there's a general rule, if you can plead a separate cause of action, you can cherry pick and you can ignore in claiming a loss, you can ignore benefits derived from other breaches. That is Bartlett in my submission, an authority which shows that's not right if your lordship chooses to follow it. With respect to my learned friend, that's wrong. The judge, with respect, was entirely right. He asked the right question. There is a general rule. and he considered the right principles. And perhaps I could invite the court to look at the judgment, and the relevant passages start at 282 within the judgment. Your Lordship have 282. I apologise, my Lord. So it starts at 278. At 279, there's reference to the KMR case, which is the correct leading authority. And the judge referred to both the majority judgment of Lord Justice Hobhouse and indeed the dissenting judgment of Lord Justice Stuart Smith. So he had both judgments in mind. 282, he referred to the passage in Horsbury, which again sets out that the test where a trustee is liable in respect of distinct breaches of trust, one of which has resulted in a loss and the other in a gain, is not entitled to set off the gain against the loss, but is liable for the whole loss. And my Lord, he then goes on to consider the position, and he does express some doubt, saying he hasn't found the question straightforward. And then your Lordships will see at 285, your Lordships will see how he puts the position. And to answer my Lord Justice Mayall's question from a few moments ago, your Lordship will see that the judge did ask himself whether there were separate breaches. And concluded that they did. But also at 286, 87 and 88, the judge then gave three particular reasons. I'm supposed to go through these relatively briefly. We don't need to rely on these, but we do say they bolster what is an obvious position. The key question for the judge below, with respect to your Lordships, is whether it's a single transaction, whether it can be said to be separate and distinct, or rather can't be said to be separate and distinct. And these three matters are just musings of the judge, which we say do reinforce the obvious conclusion. The first point is at 286, and that's the adoption point. My lady friend submitted yesterday that in the case of an adoption, it doesn't mean that the adopted breach should somehow be ignored in determining whether the beneficiary has suffered loss. That misses the point. The point the judge was making in this situation, like this, was where there have been several stages, as there had been in this case. If the beneficiary adopts the wrongdoing at stage one, it was arguable, and the judge only said it could be argued. It was arguable that the dishonest assistance could only arise at a later stage. It was as simple as that. That's the point the judge is making. The second point is the difference.
I mean, it's definitely proceeding on the basis that you can adopt in part, so to speak. You can adopt to the point where you establish that the proceeds of sale are held on trust, and then you can claim compensation as well.
Well, yes. I mean, the way I understand the judge dealt with these points is the question he asked was the right one in terms of separate causes of action, or can they not be said to be separate and distinct? And these are some of his thinkings. But overall, that was the question. And that was something which he felt it could be argued. It was something which he took into account.
But separate causes of action and single transaction are different questions. If there's only one cause of action, then the issue doesn't arise. It only arises when there are more than one cause of action.
Well, yes.
And the question is whether they all form part of a single transaction.
My lord, yes.
Yeah.
And there are plenty of cases what one can imagine where parties, it often arises in a security of a cost type situation.
So sorry, but it then doesn't help you simply to say these are separate causes of action. That's not sufficient. That's only a necessary first step.
My lord, yes.
Yeah.
But they're separate and distinct, and they don't form part of a single.
Well, you told us a minute ago that saying that separate and distinct mean different things is just playing with language. So that doesn't take you any further either, does it?
My lord, no. I think the test is, can it be said that they're not separate and distinct? And to go back to the wording used in Bartlett, the general rule is that where a trustee is liable in respect of distinct breaches of trust, one of which has resulted in a loss and the other in a gain, he's not entitled to set off, unless they arise in the same transaction.
I mean, I was wondering whether, as you've acknowledged, the judge didn't pose in terms the question whether it was a single transaction. We get any guidance from his description of the conspiracy claim, which you argued, described in paragraph 250 of the judgment. Why is that conspiracy not a single transaction, albeit in the end the judge held it was one which you hadn't pleaded?
Well, my lord, that was purely a pleading point.
I know, but why is the conspiracy which he describes in that paragraph, which is not what you pleaded, and therefore you couldn't run it, why is that not capable of being a single transaction? It's a single conspiracy.
Lord, that's a different thing altogether. The sort of situation which arises in terms of this, it's equivalent to a cross claim. Can it be said to be the other side of the same coin? There was a scheme for Mr. Ruhan, and that was an ongoing scheme over a number of years. But it can't be said that's a single transaction. Otherwise, it could go on for it simply doesn't make sense to go on indefinitely. It's such a wide term. Cause of action is a discrete matter. And really the question is it the other side of the same coin? Can it be said? It's a bit like in the security for cost cases, where there are cross claims. Can it be said that simply the cross claim is just a defence, it's just the other side of the same coin, or are they actually discrete claims? Are they so inextricably mixed up, connected, to use the expression my own friend used? And my lord, there are so many different stages here, so many different transactions which took place in between. It's not just a passage of time, but they're completely separate matters. So, Lord, with respect, it would be wrong to confuse a scheme, a general project, with whether or not two claims or two causes of action are or are not a single transaction.
Yep, thank you.
My lords, we were looking at the reasons the judge actually gave.
You've obviously reached 4:15, but if you are going to deal with the reasons quite swiftly, then we could just finish those off. If it's going to take longer, then let's leave them to the morning.
My lord, it might take a little bit longer.
Let's leave them to the morning then. So we'll start again at 10:30.
Right. that yours? Sorry, is that scribbling? Yes, that's someone else. That's the exercise that's going to wipe me out.
Wow.
You've missed it.
Given that you're going to be doing the book, let's go back to your room.
Yes.